Good evening. We are going to call the September Zoning Board of Adjustment meeting to order at 7:33 p.m. on September 18th, 2025. Madam Secretary, would you please read the notice of this meeting and call the roll?
The notice requirements of the Open Public Meetings Act have been satisfied with respect to this meeting of the Township of Verona Board of Adjustment, which is being held in person in the ballroom of the Verona Community Center, located at 880 Bloomfield Avenue, Verona. The time and date of this meeting were included in the annual meeting notice posted in the Community Center and sent to the official newspaper of the Township, the Verona Cedar Grove Times, at least 48 hours preceding the start time of this meeting. The agenda and instructions on how to comment will be provided at the appropriate time. All meetings are recorded. Those wishing to speak during any public comment period should only provide their name and municipality. Street addresses are not required. Please be advised that should a member of the public choose to state their street address, it will not be redacted from the recording. Mr. Tully. Dr. Reese.
Here.
Dr. Cortez.
Here.
Mr. Ryan.
Here.
Mrs. Murphy-Braddix.
Here.
Mr. Mathewson.
Here.
Mrs. DiBartolo.
Here.
Vice Chair Weston. Chair McGinley.
Here.
Board Attorney Massara.
Here.
Ms. Tanweer.
Here.
What is
Marco.
his last name? I want to see Marco. Mr. Navarro is also the engineer. He's the traffic expert.
Here.
And I am the board secretary this evening, filling in for Ms. Carpinelli.
Appreciate that. Would you please stand and join me in the Pledge of Allegiance? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next time, make it something patriotic. Okay. Let's start with some general information. This board deals with the issuance of variances from the Verona zoning ordinance. That ordinance establishes specific requirements for the land area in the township and regulates not only the uses permitted, but the size of lots, setbacks required, parking, signs, conditional uses, and numerous other such regulations. An applicant is never entitled to a variance. Applicants must meet specific criteria contained in the state municipal land use law by satisfying certain legal standards of proof. The burden is on the applicants to show that they should be granted the specific relief requested. Depending on the type of variance requested, applicants will need to prove special reasons, undue hardship, a balance of benefits, and other criteria. These are legal proceedings. Public meeting notices have been published, neighbors have been notified, applicants and their representatives will provide sworn testimony and be subject to cross-examination. Any action this board takes at this meeting will be memorialized in a resolution document prepared by our legal counsel that will be reviewed and adopted typically at our next regular meeting. At that time, any variances granted will become effective. That said, we are a board that conducts its business in a fairly informal manner. Applicants are sworn in, tell us what they want to do with their property and what they are asking the board to do. Board members will question witnesses, and then members of the public may question those witnesses. At the conclusion of the testimony, members of the public may make a statement regarding the application. After closing the public portion of an application, the board will deliberate and render a decision. Okay, we are up to item E on our agenda. Approval of minutes from the regular meeting of August 14th, 2025. Board members were sent the minutes in advance. Hopefully, everybody has had an opportunity to review them.
I'll make a motion to approve the meeting minutes.
Okay. We have a motion to approve. Do we have a second?
Can we second if you weren't at the meeting? No. No. Okay.
Thank you, Edith. Okay, we have a motion and a second. All those in favor, please say aye.
Aye.
Any opposed? Any abstentions?
Abstain.
I abstain.
Catch all those? Okay. Minutes are approved. Okay. Moving on to resolutions. We had one resolution from the meeting on the 14th in the case of Resolution 2025-08 for application 2025-115, 12 Highland Terrace, to construct a masonry block wall to fill in the 4-inch height differential with the neighboring property.
I'll make a motion to approve the resolution.
Thank you. And a second.
One sec, hold on. I just want to note that I'm missing from the roll call vote. I'm not indicated that I'm absent in it, so that should be amended.
Oh,
Okay.
Mr. Chairman, I just want to ask Kathleen, because I know she was pitching for that. We have, in the body of the resolution, we have the resolution number and the application number is the same. If I recall, the application number is 2025-08, and the resolution, then I think would be 115.
I'm just going with that. We can change that. I can amend the number. So I'm amending the number and adding Mrs. Murphy Braddock's, correct? And I believe the only two eligible to vote on that are Dr. Reese and Mrs. DiBartolo.
That is correct.
Mrs. DiBartolo has moved approval.
Yep.
Second, Doctor? Okay. And say, you guys all be voting in favor? Okay, everyone else is not eligible. Goodness, it only takes one. Resolutions are done. Okay, new business. Okay, I just want to say to the board, remind them that we are now entering fall and we have a considerable number of cases to hear. Appreciate having everybody here this evening because we have use variances every other week, it seems, and we have 3 meetings in the next 4 weeks. So efficiency is always an appreciated quality of a board meeting. And with that, we'll move on to our first application this evening, application 2025-07, 2 Ballston Drive. If the applicants would please come and stand at the table, our counsel will swear you in, then you can have a seat.
Can you state your full name and address for the record, please?
Kenton Gerlach, 2 Ballston Drive, Verona, New Jersey.
And when you raise your right hand, please. Do you swear or affirm that the testimony you're about to give is the truth?
I do.
Mr. Gerlach, would you give us a summary of what you'd like to do?
Yes, sir. I'm interested in putting a 6-foot fence on part of my property. The one part in question, I live on a corner lot, so the side lot of the house is what's in question. It's considered a front yard, as you all know. But my location is, I think, justifies my request. I live on Lakeside and Boston Drive. I'm directly across the street from the park. I get a lot of out-of-town traffic, foot and automobile. Um, The fact that it is on Lakeside Avenue, it's in my mind, and I'm sure a lot of other people's minds, that it's a target-rich area for criminals. I mean, they can be on 280 and on their way to Newark in probably under 2 minutes. So I'm requesting a 6-foot fence, basically for security. Um, For lesser benefits, my kids are having kids, my nieces are having kids, and referring back to the out-of-town traffic, you know, when we have something out in the yard, and you can't always be on top of everything, and that, again, is another deterrent from the kids getting off of their property or someone getting onto the property. And even lesser benefit is I have 2 dogs. I would like to let them appreciate the yard and be able to use it. And in the interest of expediency, that's all I have.
And the fence you're proposing is the one that's in the paperwork you submitted, number 1, 6-foot tall, black, aluminum or iron.
Black iron, well, it's aluminum, but they call it a black iron fence.
And if I'm looking at the picture on your survey correct, the fence does not go any further than the front of your house on Walton Drive.
Correct.
And it's behind the existing,
I have an arborvitae red hedgerow. But, you know, I mean, it's great for privacy, but it does little for security.
and are your dogs big?
I have a 35-pound and a 50-pound dog, and the 50-pound dog is a puppy. So, and he's got a lot of energy. My daughter rescued him, and I guess we're instant grandparents.
Anyone else on the board have a question of our applicant?
Will this make your, I'll call it your backyard and side yard, opposite lakeside? Would that be fully enclosed then with fence? 'Cause
It would be enclosed in on the lakeside side up to the corner of my house on the Boston side. So it'd be the whole, I guess, half the length of my property. It would end where my house ends.
is this fence on this side too? Yeah, is this fence on this side too?
That's not my fence.
Oh, that's not, okay.
The 2 homes behind me both have 6-foot, existing fences.
Mr. Chairman, I always ask this question of the applicant. Have you any discussions with your immediate neighbors about your proposal to put this up?
Oh, yeah, absolutely. They have no problem with it at all.
Okay.
And I did send out all of the registered mail as
No,
required. So
I realize you have to notify them, but sometimes it's just useful to know whether there's been any
Nope, they're all fine with
interaction
it.
with your neighbors.
And, I ran the ad in the paper, did, my due diligence.
And the fence is going to be behind the arborvitae, if I got that
Yes.
right? Okay. So you're not proposing to change any of the current landscaping?
Nope.
Okay.
Nope.
Thank you.
Have there been many robberies in your neighborhood? You're talking about security, and do you feel that that's an issue?
I can't give you examples of robberies. I can tell you I've seen people in my driveway try my car doors on my ring. I can't answer that.
I think one of the detrimental factors is that you're on a major county road. We've had recently several applicants looking for some sort of fencing or some sort of security along county roads like Route 23. So it's not an unusual step for the board. It's the reason we exist is because the uniqueness of the property. If this property were all the way up the hill or in the center of town, putting up a 6-foot fence in the front yard would probably not be an acceptable solution. But where it is probably an acceptable solution, both for the safety and security and more for the people in the house who want to be able to use the yard and not be running out onto or having a ball roll out onto a major highway.
Are you planning on putting shrubbery in front of the, I understand that along Lakeside, there's shrubbery there, there's trees there. You're putting the fence behind those trees. Are you planning on putting any shrubbery on the other side of your house, where these X's and O's are here?
I don't think I need a variance to put the fence on the other side of the house.
I didn't hear that, Larry.
I was under the impression that I didn't need a variance to run a fence on the other side of the house. I really have no plans for it, no. No, the other side, please.
Your back neighbor also has a fence along Lakeside, yes?
I have two neighbors that actually share my yard, and one has a 6-foot vinyl fence, and the other one has a 6-foot wooden fence. And my neighbor too, if you're looking out at Folsom Drive, to my right also has a fence. It's 4 foot. But a 4 foot wouldn't really be much of a deterrent, and it certainly wouldn't keep the dogs in.
Mr. Gerlach, is it your testimony that you're not planning to take down the arborvitaes, the fence will remain screened?
Absolutely wouldn't take them down. They're a nice privacy, they're great for privacy, like I said, but they're nothing for security.
And I'm sure our engineer has looked at it and determined that the site triangle on the corner is still clear.
Mr. Hurley, I'm not sure where my microphone.
Actually, I can hear you.
Just to interject, we may have some problems with the microphones tonight. So you may have to share. There was a charging issue with them.
I thought red was off. I've only been doing this for a lot of years. Mr. Gurley, I just want to be clear, you have no intention of taking down the arborvitaes, as the chairman asked.
No intention at all.
Normally, we would add that as a condition if this application were approved, a condition that that screening shall remain in front, whether it be the arborvitaes or anything else. So if that appears in the resolution, that would be acceptable condition to you.
Absolutely,
Okay.
understood.
Thank you.
Any other questions from the board members? Is there anyone from the public that has a question of this applicant? Seeing none, I would ask, is there anyone from the public who would like to make a statement about this application? Again, seeing none, I would close the public portion of this application and move to board deliberation.
Yeah, I mean, conservative layout for the fencing, so obviously just for the intended purposes, stated what he was going to do in terms of utilizing the existing landscaping to screen it. We've seen other instances where, don't compare one to the other, but not like the application is looking to enclose the entire property to the maximum extent possible. So, I mean, given the conservative nature, exactly the purposes intended and location, I'm completely for it.
Yeah, I agree. I don't see any concerns in this particular fence going up. It'll be shielded from with the trees on the lakeside, so I don't really seem to have a problem with it.
I have no problem with the applicant's request. I also live in a corner house, and I personally have a bias against how the ordinances in this town are written to discriminate against people with corner houses. So the request, I think, is very reasonable, security, and my only problem would have been with the landscaping. He's agreed to accept that as a condition of approval, so I would be in favor of granting the relief that he's seeking.
See, we're moving in a direction. Is there anyone who would like to make a motion?
Can I just make one statement before we do? I'd like to say that I'm inclined to agree with all the statements that have been made, but I would also like to state for the record that I find the applicant's statements about Newark to be really distasteful. I just wanted to say
I grew up in
thanks.
Newark. I was born in Newark.
Okay, that's fine. I
So,
just, for the
just
record,
being realistic.
I find it distasteful.
Sorry to offend you.
And I'm inclined to vote for approval. We all know how I feel about white vinyl fences, so I'm glad that it's black metal.
Motion from anyone?
I'll make a motion, Mr. Chairman, to approve the relief that the applicant is requesting, subject to the conditions regarding the landscaping. Is that-
Second?
I'll second.
Do we have a roll call vote?
Dr. Reese,
Yes.
Dr. Cortez,
Yes.
Mr. Ryan,
Yes.
Mrs. Murphy Braddix,
Yes.
Mr. Mathewson,
Yes.
Mrs. DiBartolo,
Yes.
Chair McGinley.
Yes. By my count, the motion passes. Resolution will be drawn up and then brought to our next meeting in October, next regular meeting. And at that time, we'll set to go.
Thank you very much.
Next up on our agenda, application 2025-02, 544 Bloomfield Avenue, also known as 10 Park Place. This has been carried from April 10th, where we heard testimony, carried from the July 17th meeting where no testimony was heard, and carried from August 14th meeting where no testimony was heard. Sorry. I was trying to throw off the stenographer.
You want to get something on the record, say something while I'm over here.
I don't know, the two of you missed one meeting and you totally fall apart.
There we go.
He's not going to sign down and you don't know how to work the microphone.
A little rusty after my vacation.
Do you want to take this?
Counselor, if you'd be
All
so
right,
kind
we're
as
good.
to bring us up to date.
Absolutely. Again, for the record, Reggie Jenkins, Trank Isabel, Siddiqui, and Shadanian on behalf of the applicant. I heard the chairman's general admonition to the board about being efficient and that you have a lot of stuff coming down the hill at you later on, so I will try to move this quickly. And hopefully we can be completed this evening. So, again, up to this point, we have provided a substantial amount of factual and professional testimony in support of this application, which is seeking simply variance relief to allow for the operation of a prayer room at the subject property. We've stated that this is a prayer room that's brought about because they had vacated their previous worship home. They're in the process of looking for another permanent home. This property is a stopgap in that process. And we have given extensive testimony first with regard to the operations and the times that prayers will commence, the times that prayers will end, and the frequency of them. We have spoken about that consistent, and we've stipulated that the police department has recognized and reflected that the times of operations really do not coincide with the beginning and ends and out discharge of children from the schools. But even with that, lack of interference, we have stated that we are more than happy to cooperate with the local police department with regard to coordination for traffic, and if additional presence were needed and called for, we'd be more than willing to do that. The client would be willing to do that. We've noted that also in this intersection at the times of school hours, there is a crossing guard, which is an additional point of safety, and hopefully that lessens the concerns. We have stipulated, and we'll again say that in terms of the population of the applicant, it is always been 50 to 70, but we have no problem stipulating that the congregation as it stands right now is going to be 100 people. So we're not looking at any more than that. There was considerable back and forthing, I think, from both the board and the public with regard to that, but I'm hoping that that is a clear understanding, that we have a clear understanding on that point. Also, we have again stipulated that this is not to be used as an event space. This is not for funerals or weddings or parties. This is not a space that is going to have amplified speech. There's no going to be broadcast of a call to prayer. There's no, and we would stipulate that there is not going to be any electronic speakers, even if they were operated, not to be heard outside of the four walls of the premises. So I just wanted to remind the board of those stipulations and things we're seeing, because at the end of the day, we're trying to show that this is going to be a quiet, orderly operation that is not going to be disruptive in any manner that I think there might have been particularly public concerns surrounding it. So I'm not going to rehash every jot and tittle of the testimony that we've submitted to this point. We have what I hope are our two final witnesses in regard to this application. I would like to have our traffic engineer just round off the testimony that he gave the last time, because we wanted to make one point very clear with regard to the ingress and egress of this site, that there is an additional point that, if it wasn't called out before, we'd like to call it out now. The traffic testimony that was given previously and the calculations that were done on the most conservative bases, so that, assuming that this one point in and out was the only one. But we do want the board to be mindful that at this property, there is a separate egress point for the vehicles that may be in the general area. And then finally, we have our planner who will, wrap this up in a nice tidy bow for you. So, Mr. Chairman, unless there are any questions of me at this point, I'd like to bring up our witness, Andrew Vishio.
Everybody's good?
Thank you very
Mr.
much.
Jenkins.
Is that one okay? Good.
Let's see if red means on. Good to know.
All right. Do we consider him previously sworn and accepted it?
If, as long as the witness understands he's previously under oath and his credentials remain in good standing in the state of New Jersey, then we're good to go.
Thank you very much. Again, why don't you just reacquaint the board with your name and where you're from?
Of course.
Professionally, not like regular.
Of course, my name is Andrew Vicchio. I'm a licensed professional engineer in the state of New Jersey. I testified at the last hearing. My license is still in good standing.
Thank you. And as I alluded to, we're not looking to go through all of the testimony that you've presented previously, but am I correct that for this property, that there is an additional, this property in the surrounding area, that there is an additional point of egress that this board should be apprised of and that's worth considering?
That's correct, counsel. And it became apparent to me as I reviewed the video from the last hearing that one factor may not have been emphasized enough. So I just want to briefly take a moment here at the top of this hearing to go over that. So as counsel mentioned, while our traffic impact study took a conservative approach and routed the site-generated traffic leaving the municipal parking lot through Park Place, this parking lot does provide another egress point onto Bloomfield Avenue, adjacent to the existing Chase Bank. This is a right turn only driveway. Assuming the use of this additional driveway by new vehicles that desire to make a right turn to head westbound, no build conditions are maintained at the subject signalized intersection without the need for any traffic signal timing adjustments. So to recap, the review letter issued by the board engineer dated June 5th, 2025 found our methodology to be acceptable. I provided additional clarification at the last hearing wherever it was requested in the letter. And the one comment in which Boswell, the reviewing engineer, and I came to different conclusions was regarding the need or lack thereof of traffic signal timing adjustments. And that one comment, when taking into account the additional egress point, is no longer relevant. So that just concludes the direct testimony that I wanted to add this evening, and I would be happy to answer any questions.
Thank you very much.
So just to be 100% clear, there's no anticipated changes to the traffic signaling along Bloomfield?
Correct.
I do have a question. So when you do your analysis, it's based on kind of a typical traffic pattern. How often do you take into account things that are atypical, for example, accidents or some other kind of emergency type of situation? And the reason why I'm asking is because as far as I know, I think we've had 2 recently since you guys have been here, right at that intersection. And I want to know if you take that into account when you do your whole analysis.
The traffic analysis that you would see for an application like this makes an effort to study representative traffic conditions, not traffic conditions under a circumstance like something that would need emergency services response. There are entirely separate types of traffic studies that look at intersections or corridors more holistically for safety concerns. But in terms of the traffic analysis that is typically requested and required as part of an application like this, that is not the focus, because those conditions are not representative of what people might experience on a day-to-day basis.
And we're also not going to see a site plan, correct? There's no parking, I mean, I know parking's not a requirement here, but there is a separate lot that is dedicated to this building, in addition to the municipal lot that's back there. So we're not seeing any site plans, correct?
I can't speak to that. I would have to defer to council on any documentation like that that has already been or may be provided to the board.
If I may, that there was the aerial map and location mapping provided by our engineer, which details the entirety of the property.
This is not exactly a site plan, though. No.
Are you finished with your question? Did you take into consideration the fact that there are school parking spaces set aside and how many cars will be able to fit? You may have touched upon this, but I have forgotten, so I wonder if you could sort of jolt my memory here. How many parking spaces are available there? And there are those that are included in the schools, for the school faculty. And then there are spaces that are set aside for Lakeside Deli. So how many parking spaces will you be using and how many parking spaces are available for you?
There are 75 parking spaces in the municipal parking lot that are not allocated for specific users. That was included in the submitted traffic study and confirmed in the review letter. Trying to find the comment number. Comment 14 indicated that the parking inventory conducted in 30-minute intervals was acceptable. That didn't speak to the number of parking spaces that are for other users, but I can confirm that the 75 parking spaces identified in the traffic impact study are not designated for the school or for any other type of user.
The 75 that are free.
75 general purpose.
If I may just do a follow-up question with regard to the parking, in addition to the parking availability within the adjacent lot, am I correct that we've also identified additional and substantial on-site parking, on-street parking in the immediate area?
That is correct. There is a significant amount of on-street parking in the immediate vicinity of the site. That is documented in the submitted traffic impact study, which found that just along Lakeside Avenue alone, there are over 100 available parking spaces within a reasonable walking distance.
And also, isn't it of some significance that the nature of the need for parking is, my word, somewhat intermittent in the sense that we've identified that the population, when they are there, it's a prayer time of about 20 minutes. And that you'll come, pray, and leave. This is not permanent on-site parking from 9 to 5, correct?
Correct. These parking spaces would be used, my understanding is Friday prayer might last a little bit longer than that, but this is not someone arriving, parking at 9 a.m. and departing at 5 p.m.
So that's like any other, if this were the commercial space that is also zoned for people coming to that location, parking for a little bit and leaving.
Correct.
Thank you.
Mr. Chairman, I just want to clarify, this information is all referenced in this study that you submitted at the last meeting, correct? There's been no addendums to this, other than the fact that I think you just mentioned that you didn't include the egress onto Bloomfield Avenue from the parking lot?
That is correct.
That would be an accurate statement.
That is correct.
Okay. So just to refresh my memory again, because this has gone on for a while, one of the variances is obviously, besides the use variances, the parking space allocation. How many spaces are you deficient in terms of the number of people who are using it that are actually on the site? Did we agree to a number in that area?
I'm going to defer to the next witness, our planner, who I think can speak to that in a better position than I can.
Okay, thank you.
So just to confirm, Mr. Jenkins, when you were just talking before, you said there's a maximum of about 100 people in the congregation, right? That's
correct.
What you just mentioned before. In the Boswell letter from June 5th, it says that Friday services will be between 50 and 70 people. Does that sound accurate? So not everybody comes, right?
Correct.
And then what's the latest time that they would depart on an afternoon, on Friday afternoon?
2 p.m. is anticipated to be when people would depart. So I would anticipate 2 to 2:30 p.m. being when the majority of prayer goers would depart.
Thank you.
That egress lane that you referenced, is that Verona property or is that Chase property?
It's Verona property. The property line actually sort of runs along the ATM canopy, if you were to look at it on an aerial.
I actually used it this evening.
You think you also stated that the egress from there, just to clarify, is to the right on Bloomfield Avenue, so that anybody who came from the opposite direction, I think would it be reasonable to say that they would not go out to the right and circle all the way around to come back on the other direction? They would still be more inclined to go on to Park Place and wait for the light to change and make the left turn. Is that a reasonable assumption, do you think?
That's reasonable.
Thank you. Just another follow-up to that. Very familiar, that happens to be my bank. The sight line, as you exit that, from that lane next to the Chase Bank, I find it very challenging, Stephen, to make the right turn coming out of there. In your expert opinion, am I exaggerating that, or is that really a challenging right turn, especially in certain parts of the day when traffic is very heavy on Bloomfield Avenue?
Right, I understand where you're coming from. It does require you to inch a little bit closer to the travel lane, but once you do, then you are able to see oncoming traffic, and I think the numbers back that up. There were 39 vehicles that made that right turn after school dismissal on September 16th, just 2 days ago.
Do you also take into consideration pedestrian traffic along the sidewalk in front of that bank? Because that's another when you're driving there, you're coming out, you not only have to worry about the cars, but especially when school is getting out or when there's a lot of traffic on Bloomfield Avenue, you have a double responsibility there of checking for the pedestrians as well as the traffic on Bloomfield Avenue. Is that reasonable? Do you take that into account, I should say?
Absolutely, we take that into account, but to give it a sense, to give you a sense of scale, the 39 number that I mentioned just now, that is in the half hour after school dismissal. We are only anticipating that 12 prayer goers would make the right turn to head westbound, so significantly less than that number.
Thank you.
And again, it's not all at the same time. As we've stated, that our times, the proposed times for the operation of the prayer room, are different from those of the school days.
Absolutely. The number 12 that I just stated, that is not going to be on top of the traffic generated by dismissal. That would happen well before 2:59 dismissal at the school.
Well, by the same token, many of the kids that, if they're getting out of school, a lot of them maybe would stop for an ice cream or go into the Lakeside Deli. So that would also not necessarily be a steady, there could still be a fallover period after the dismissal time, where you still have a significant amount of pedestrian traffic, specifically from the school children. I think the crossing guard, for example, I think is required to stay there till at least 4 o'clock. I could be mistaken about that. So there is an anticipation of pedestrian traffic there, both because of the severe consequences of turning and also people wanting to get across Lakeside Ave, but like Bloomfield Ave, going to the park. So it's a very challenging pedestrian and car situation.
Understood completely. However, that high level of pedestrian activity that we all know occurs after dismissal, school dismissal, occurs well after when Friday prayer would end.
And just to confirm, there is no parking requirement for this, correct, in this zone?
I'm going to defer again to my colleague who will be up next.
But yes, but that is our contention.
So in theory, we can, build a church or a mosque or something like that right where, like the old IHOP was, and there's no parking requirement there, right?
And for the record, all of your parking availability was public parking. Is there any private parking in that lot directly behind or on the property?
Yes, there are many spaces in the municipal lot that are designated for the school or certain businesses. I don't know the specific different users where those spaces, who those spaces are allocated for, but the parking availability numbers within our traffic impact study only accounted for available spaces that can be used by the general public.
Nothing in the smaller lot that comes in off of Park?
Oh, no, not that, as you're driving down Park towards the ball field, that small asphalt lot.
Right.
No, it did not account for availability there.
Okay.
That's the one that's right at the perimeter of the building, right?
We did not, the parking availability numbers in the submitted report did not include any spaces that might have been available in the lot that was just mentioned.
I guess this is another benefit of a site plan because we could tell what the property lines are and whether or not that smaller lot is inclusive of that, kind of smaller lot that we're talking about. Mhm.
Anyone else from the board have questions of our traffic engineer? Seeing none, I would ask, is there anyone from the public who has a question of the traffic engineer on the testimony that he's presented this evening? Okay, seeing none. Mr. Jenkins?
Thank you very much. At this point, I'd like to ask that our planner, Matthew Seckler, be recognized. As soon as he gets his easel.
Can you first state your name and address, business address for the record?
Certainly, it's Matthew Seckler, that's Seckler. I'm with Stonefield Engineering Design. Address is 92 Park Avenue in Rutherford, New Jersey.
And Mr. Seckler, now if you raise your right hand, do you swear or affirm that the testimony you're about to give is the truth?
Yes, I do.
Thank you. Mr. Seckler, can you provide the board with your current position and professional background, please?
Certainly. I have a Bachelor of Science in Civil Engineering from Union College in Schenectady, New York. I have a Master's in City and Regional Planning from Rutgers University. I'm a licensed professional engineer and professional planner in the state, accepted as a professional planner in over 80 boards in the state of New Jersey. I don't think this one, but many other ones around here.
Do you know Frank Riggs?
Yes, I do. I did average in his class.
Very good.
He graded on a curve, thankfully.
Thank you.
I don't have a problem with the witness. We accept him as a professional planner.
Correct.
So, Mr. Seckler, what I will ask is if you could describe generally what you and your office have reviewed, anything that you have prepared, and then your conclusions with respect to this application from a professional planning standpoint.
Certainly. As part of this project, our office and myself have reviewed the site. We visited the site. I've reviewed all documents that we prepared and submitted, including the traffic study. We've also reviewed the 2022 master plan that Verona has published, as well as the zoning ordinance, the municipal land use law, relevant case law, which I'll reference later on, as well as I've listened to or read the transcripts or videos that were provided from the previous hearings related to this application. So overall, this project, I'm going to bring up aerial exhibit on the screen.
And Mr. Chairman, while he's doing that, and Mr. Becerra, I think I've lost track as to what exhibits we may be up to. If we want, or if we just want to mark it as, again, A1 with today's date.
How about September 1? Or, well, it might be September 18, 1.
Okay.
And just to orientate the board and the public, it's really difficult to see. This is an aerial exhibit. It's numbered 1 of 1. It's prepared September 18, 2025. What it shows is a general aerial photograph, Google image of the subject area and community. We've outlined the subject site in magenta. Bloomfield Avenue runs left to right along the page. North is up. You can see Park Place and the public parking lot that's in the rear. Again, this site location I don't think is a surprise to anyone. You've heard a lot of testimony, but just putting on the record, this is block 1703, lot 68. You've heard the average address, 10 Park Place, 544 Bloomfield Avenue. It's this L-shaped property, and as the board was just talking about, has building access along Bloomfield Avenue, also has frontage along Park Place, with that small kind of asphalt, undefined parking lot in the rear of the site. The site itself is a three-story building, and the application proposes no expansion. So again, what the building looks like from this aerial, no changes. What we're changing is inside the building to accommodate the proposed use, should this board act favorably on the application. The site itself is located in the TC zone, which is the town center zone. That zone allows for uses such as retail stores, which could be 7-Elevens, bakeries, cell phone shops, full-service restaurants, something like a Chipotle, theater or motion picture uses. Also allows personal service, which could be nail salons, dry cleaning, tailors, smoothie bars, things of that nature, as well as daycare. All of those are permitted uses in the zone. There are also conditional uses that relate to mixed uses. So again, you could have those retail on the bottom, and if you meet certain conditions, office or residential above. In that list that I mentioned, I did not mention house of worship because it is not listed as a permitted use in the zone, which is why before this board seeking a use variance. I guess getting to the definition of house of worship, because in listening to the testimony and questions of the board, there was some discussion as to the fact that it is called a prayer room on some of the application materials. Some of the exhibits and plans have called it a house of worship, but I want to confirm, the definition of house of worship and indicate how this site or this use does meet that definition. So per your ordinance, and this is section 150-2.3, defines a church or house of worship as a building or structure or group of buildings or structures which by design and construction are intended for the conducting of organized religious services and accessory uses associated therewith, but not including missions, district offices, or regional headquarters of a religious group. So your ordinance clearly has a definition that if there is religious service or those type of things such as teaching, praying, house of worship, if it's more of the administrative, basically just administrative, such as district offices, regional headquarters, not considered a house of worship, probably would have a definition more related to the office type use. So my review of that, and also I believe your zoning officer as part of the zoning denial that led us to this board, has classified this as a house of worship. And again, I concur with that and believe that that is the proper definition for this type of use. Next up would be determining where a house of worship actually is permitted. And I do have another exhibit, and I actually have a handout for this since it's not the best quality image when it's blown up.
And we'll mark this as A2, September 18th.
This is a two-sheet exhibit, and I prefer whether you want to call it number 2 or 2 and 3.
It's one exhibit, you have page 1 and page 2.
Yes.
Yes.
So, just to enter this into the record, did I have enough? I've seen other copies of these. What this is titled is Zoning Map Exhibit, sheet 1 of 2, and there's 2 and 2 of the rear. They prepared September 18, 2025, prepared by Stonefield Engineering. And I will indicate with today's date. 2. First page is an excerpt directly from your zoning ordinance of the semi-public zone. This is the zone where house of worship is permitted within the municipality. So the only places where we could locate a house of worship like we're proposing, and not be before this board, instead be before the planning board, would be the areas that are outlined in the blue and light blue crosshatch. Just to kind of help you figure out where you are, in the very center of the page is us, outlined in red. And you can see all the other sites in which you've outlined based on the various house of worships that are included within this house of worship zone. And again, this is from your zoning ordinance 150-17.18. Taken directly from it. stretched out and put onto our title block. Again, you can see the location of many of these houses of worship, Our Lady Lake Church School and Parking Lot, United Methodist Church, Calvary Lutheran Church, First Presbyterian Church, Holy Apostle Church, and so on as you kind of go through the town. I would note that the vast majority of these sites actually pre-exist zoning altogether. I believe the first zoning ordinance in Verona was adopted in 1939. Looking at some of the dates of some of these buildings, I know First Congregational Church seemed like it was built in 1896 and then either expanded or rebuilt in 1914. Our Lady of the Lake Church, 1924. United Methodist Church, 1909. Calvary Lutheran Church, 1928, and so on. So the vast majority of the houses of worship that are in the permitted zones predate zoning, and I anticipate at one point, since they were already operating, the zoning basically came after and basically overlaid on top and made those permitted uses in those zones. In fact, again, looking at this map, I don't believe that any, maybe the Jehovah Witness Congregational in the United States, was built in the 1950s. I think that's the only one that probably came after zoning. But again, this zoning map, which I believe was done in 2011, again, has really looked at what's actually in operation and overlaid the SP zone on top of it. So again, I don't believe there's any sites in the town where we could go in and basically have our use be permitted where there's not already existing religious use or house of worship and occupation. So there's no ability for an applicant like us to go in and be before the planning board as opposed to before this board of zoning. Turning this sheet around, the second page of your package is just the overall zoning map. Again, this is pulled directly from your zoning ordinance. This is the 2011 zoning map. Again, our site is located in the center of the township. We are that maroon color, which is the town center, which generally includes the sites that are fronting along Bloomfield Avenue. You can see, kind of behind the opposite side of Bloomfield Avenue, you do have that TC zone, town center zone, with those semi-public SP zone, the religious uses, just behind those buildings that are fronting along Bloomfield Avenue in the TC zone. You can see along Park Place, immediately across the street from us is still that TC zone, but as you go further back, you start to hit the R50B medium and high density residential zone, which again, I think a number of our neighbors here, I believe are located in that zone, but we are in that TC zone, which again, assumes or encourages uses that bring activity. Again, those TC zones, retail uses, service uses, basically vibrant uses that are looking to bring activity to the Bloomfield Avenue corridor. So earlier I did read the definition of the house of worship per your ordinance, and again I believe that we clearly do meet that definition because we are conducting organized religious services. So the next threshold as part of this application is to identify and I believe classify this house of worship as an inherently beneficial use. And I want to read into the record, and I believe this was already done so, but read into the record from the municipal land use law, the definition of inherently beneficial use. This inherently beneficial use means a use which is universally considered of value to the community because it fundamentally serves the public good and promotes the general welfare. Such a use includes, but is not limited to, a hospital, school, child care center, group home, or a wind, solar, photovoltaic energy facility or structure. Clearly in that list, they did not list house of worship, but again, right before they list those items, they say, but is not limited to those type of uses. Now, that is the statutory criteria for an inherently beneficial use. The courts in New Jersey have heard many cases related to religious uses and whether it's considered inherently beneficial use. Specifically, the one I would reference is House of Fire versus Clifton. Again, I believe this was referenced in an earlier hearing for this application. But specifically, House of Fire in Clifton was related to a church that was proposed in a residential district. It actually was a conditional use in that district. It did not meet a couple lot dimension criteria, so it was a use variance because it did not meet the conditional standards. But in that case, and this I'm reading from the case, it actually states that all parties agree that the construction of a church is an inherently beneficial use of the land. And it refers to another case called State v. Cameron, which was a 1985 case, where it says, courts have held that religious activity itself is in furtherance of public morals and the general welfare, and that religious institutions enjoy a highly favored and protected status, which severely curtails the permissible extent of governmental regulation in this area. So again, the case law to me is clear that the courts have found, while not statutorily inherently beneficial use, the courts have found that houses of worship meet that, but not limited to phrase in the definition of inherently beneficial use, and that this application here would meet that standard. Now, the importance of inherently beneficial use, or that determination, leads us to what threshold we need to meet in order for this board to grant a use variance. I know this board hears a lot of applications, typically for commercial, non-inherently beneficial uses. The board has to hear, or the applicant has to meet what's considered the Medici standard, basically the highest level of proofs that they need to show in order for this board to grant approvals for a use variance. If you're an inherently beneficial use, you do not have to meet that high standard. The test is a more relaxed test known as the Sika balancing test. And kind of comparing the two of them, if we were seeking to build a restaurant in the residential zone, we'd be before this board having to meet the Medici standard, which, as part of its enhanced burden of proof, requires us to show that the site itself is particularly suited for a site, and there are specific special reasons why it should be approved and advances the positive criteria, as well as that it does not have a negative impact to the public good, as well as the master plan or zone plan. So you have to satisfy the two negative criteria, as well as show on the positive side that the site can be granted based on special reasons and particular site suitability. With a inherently beneficial use, it is assumed that it's because it's beneficial. We do not need to meet that positive criteria. We do not have to show why this site is specifically suited here, and we do not have to show that there are any special reasons why this application be granted from a positive standpoint. It's assumed in the fact that it is a beneficial use. We also do not need to show that we do not hamper or burden or have a detriment or impair the master plan or zone plan. So instead, the balancing act that we have to do and show this board, as outlined in the Sika versus Wall case, which is a 1992 case, is we need to identify the public interest at stake. We have to identify detriments that may be occurring upon if the board approves the application. The board is to consider appropriate conditions that helps reduce those detriments if there are any. And then they basically have to balance the inherent benefit of this use with any substantial detriments. And that's the path that the board has to go down, as opposed to looking at what does the master plan say? What does the zone plan say? And is there some specific special reason why this application should be approved? So it's a much relaxed standard. In fact, in that House of Fire case, it did, I'm quoting from that case, it says, in that case, the proposed use is inherently beneficial and applicant's burden of proof is significantly lessened. Not only does inherently beneficial use presumptively satisfy the positive criteria, but satisfaction of the negative criteria does not depend on the enhanced quality of proof. So again, what this applicant is required to show is not the same as your standard commercial, non-inherently beneficial application. So when performing the Sika balancing test, the first thing we need to identify is the public interest at stake. One, religious uses do obviously advance individuals and communities that look to seek and advance moral rectitude and general welfare. In addition, the applicant has discussed their need for prayer space for residents in Verona and the regional community. It's important to recognize that these inherently beneficial uses, such as a hospital, you're not necessarily just looking at, the 2 blocks around the hospital or even the town around the hospital. From a regional perspective, is there a need or is there a public interest at stake with this application. And again, I think you've heard from the applicant earlier that they currently or previously were in a spot in Caldwell. They're looking for a new space just to kind of temporarily call home. And then obviously their eventual goal is to have a permanent space. But clearly there is a public interest for their community, as well as the fact that, again, the courts have found that religious institutions do promote general welfare and moral rectitude. The next aspect of the application is that we then need to identify any detriments that may occur if the board grants this approval. And they speak to substantial detriments, because obviously every application may have, some activity. And I think in this case, when we judge the detriments, we should be judging the detriments versus what is allowed in this zone. This is not a house of worship going into a residential zone where it's a zone that has very limited activity, maybe a single-family house with a couple cars going in and out in a day. This is a house of worship, inherently beneficial use, going into a zone that is a retail business zone. It is going into a zone that expects there to be pedestrian traffic, vehicular traffic, noise. Again, if we had a bakery, a bagel shop bakery, they could be cooking at 5 in the morning, getting ready for the day. If this was a full-service restaurant, which is permitted, they could be having and serving meals later into the evening. If this was a dry cleaner, you could have people coming in and out, needing to find a parking space, coming in and out throughout the day. So when you look at the detriments that may occur based on this type of use, again, we need to balance it for what is expected of the uses that are in this zone. And again, you've heard significant testimony about traffic, noise, just general activity, concern about the site. And I don't believe that there's any substantial adverse impacts, especially when you consider the next piece of the SECA balancing test, which is the board is to consider appropriate conditions to reduce potential detriments. You've heard from our council that the applicant, while they expect to have, even during their peak times, between 50 and 70 prayer goers on a Friday, the fire official has deemed that this site, I believe, could fit up to 153 people based on fire code. And they're willing to basically cut that down by a third and say, listen, we will never have more than 100 people here. In addition, houses of worship a lot of times have life cycle events, funerals, weddings, those type of events. You've heard from the applicant that they understand that that is a possible detriment to the community to have those things. And they initially came in here not proposing and will continue to allow for a condition that does not allow for those type of life cycle events. So I think that's important, again, when the board is going through this balancing test, what are those potential detriments and what conditions can we put? I think the applicant is coming to the table with, potential conditions that they think will help satisfy some of those potential negative impacts. In addition, you did hear, I believe there was some testimony about a noise study, and that they've agreed to not have, outdoor call to prayer, and they would be obviously working with the township on making sure that, noise, especially during the morning prayer, does not extend beyond the building, can't be heard within the community. So again, I do believe that we do not have any substantial detriments, and the board, clearly they could consider other conditions, but the applicant is coming forward with a set of conditions that they believe would help reduce any potential negative detriments. Lastly, the board has to balance, that compelling, inherently beneficial use, the fact that this does clearly advance the general welfare, and that's what the courts have found, with those potential detriments, even with the conditions in place. And again, I think that this application does advance that. I think they've actually advanced a number of the purposes of the master plan. The master plan speaks to, activity and it speaks to activity in the Bloomfield Avenue corridor. You do not want to have you don't have a vacant building there. I think the applicant spoke to the fact that, they don't basically bring in food to their prayer rooms. So this, does allow for their prayer goers to frequent the businesses along Bloomfield Avenue, extending into that commercial district and helping add vibrancy to that district, which was one of the economic goals outlaid within the master plan. So I do believe, again, that this is an application that's clearly advancing, the purposes of zoning, as well as provides a positive good to the community. So the seeker balancing test and then inherently beneficial use was state court cases related to the state and municipal land use law. Federally, there are also statutes and acts that relate to religious institutions as they relate to zoning and land development decisions. There is an act called the Religious Land Use and Institutionalized Persons Act of 2000, commonly known as RLUIPA. And basically what that does is it presents, it basically codifies and prohibits the government from imposing land use regulations that imposes substantial burdens to the exercise of religion, including religious assembly, unless the government demonstrates that by prohibiting these religious uses, that that there's a compelling government interest. That there's a compelling government interest. And I think what that relates to specifically is when boards decide on land use applications that relate to religious institutions, they need to identify, if they are going to not find favorably, reasons of significant health and safety as a reason why you don't approve this type of application. The RLUIPA Act is meant, the way that I read it, to make sure that government does not propose a substantial burden to the expression of religion. And what I mean by that is that there needs to be basically a fair share between different religious uses, meaning that you can't have a certain zoning regulation for one religious use versus another. You also can't treat secular uses more favorably than religious uses. And the fact that when acting unfavorably to an application, there needs to be compelling government interest, which, again, the way that I read it is health and safety reasons. A board should not deny a religious application because the architecture is not what the town likes. If the building is not fire coded correctly, in which there could be a health and safety issue, if you don't comply with the setback, and that could be a health and safety issue with the property next door, I believe that the RLUIPA allows for boards and municipalities to deny those type of applications. But for, I would say, non-health and safety issues, which could be parking space dimension, could be again architectural features, the way the roof looks, I don't believe those are considered compelling government interest. And the boards are supposed to look at the least restrictive means of furthering the government's intent, meaning you do not want to cast a wide prohibition. You're trying to identify what are those compelling government interests, what are those health and safety issues, and can you provide ordinances or restrictions that basically focus on that and doesn't hamper the expansion or allowance of religious belief. Now, typically when I look at those health safety issues, I look at the type of review letters that we've gotten from the board and experts within the municipality. So police letter, fire letter, those type of letters, I look at to see whether there is a compelling government interest, because I look at the fact that those police powers, those safety powers need to be met in order for the applicant to move forward with an application like this. And if they are not met, I do believe the board has their obligation, as an obligation to potentially act unfavorably on a project. But so far, I've looked at, again, fire letters, police letters, board engineer letters, and don't see anything that rises to what I would consider government interest that would allow for a health safety denial to this application. So overall, again, as part of this application, I want to emphasize, again, that we are in a TC zone, a business zone, one that assumes that there'll be people driving to a site, people parking, activity, pedestrians, all that, different hours. You may have TC uses in the morning, some at night, some when school gets out. You have that smoothie shop, I guarantee you it's packed with kids right after school gets out. And again, I think that this use actually blends in well. It does not have extremely high peaks at time periods when the roadways around it have extremely high peaks. We've identified that there is available parking in the area, although I'll get into a second, I don't think we require any parking. But again, clearly our patrons, our worshipers will need a place to park. I do believe that we found that there are available spaces to park. So again, I think that this site fits in very well with the zone and very well with the area that it's been located in. I believe, again, that this meets the standard of inherently beneficial use based on New Jersey case law. I believe that leads us down that SECA balancing test in which we look at what are those detriments, what are those substantial detriments that have been identified, and are there conditions that can be put in place that could help satisfy those detriments. And again, I think that the applicant has done that, and I think when you balance and you weigh that, and you weigh the fact that, yes, you may have 50 people coming here at 1:30 on a Friday, I think when you look at the fact that you are advancing purpose A of municipal land use law with this, which is health, safety, and general welfare, I think that, clearly the health, safety, and welfare positives of the inherently beneficial use, I believe, weigh out on top versus, some level of traffic that's already expected within the TC zone, some level of parking that's expected already within the TC zone, some level of noise, within a TC zone. So overall, I believe this board has the statutory criteria before them that would allow for this application to be approved. I want to talk very briefly on the parking standards. Again, your ordinance does allow for uses within the TC zone to be exempt from parking as long as they do not have an addition or new construction of greater than 1,000 square feet, which we do not. We're not changing the building at all. And the other reason why you would need parking is if you have a full-service restaurant or limited restaurant with more than 50 patrons, which again, we are not a restaurant. So I don't believe that condition applies either. So again, I think really the only variance before you is the D1 use variance, which I believe we've satisfied as part of the SECA balancing test. And I believe that's the only variance that we are seeking before the board tonight. So overall, again, I believe that this application is approvable. I'd be happy to answer any questions of our council and the board and public when the time comes.
Mr. Steckler, thank you very much. Mr. Chairman, I have no further direct questions of Mr. Steckler.
Does the board have any questions of our professional planner?
Mr. Chairman, I just wanted to clear something up about the exhibit that was given, and maybe this is something where our zoning officer could weigh in. The houses of worship that are identified on the first page of the exhibit, does it include the existing Islamic Center on Gold Avenue? Now, I know the ordinance says it would go to 2011, it was based upon the 2011 zoning map. Prior to the existence of the Islamic Center, there was a Jewish temple there. So should that not have been included as one of the sites, that is in an area that's, that's semi-public?
That area is not a semi-public area, that's actually a residential.
Okay.
So I believe if they were you were marking out the semi-public area, that's why it was not included on it.
Very close to where the Holy Spirit Church is, for example, it's far enough away that it doesn't qualify.
Well, it's just not in that zoning district.
Okay. But why wasn't it put in the zoning district? That's my question. Because obviously a lot of these, as the planner just stated, were sort of grandfathered in, if I understood it correctly, that they existed there before the zoning ordinances were drawn up. And I guess my contention is, I don't know off the top of my head when exactly Congregation Beth Am was established.
Right. I don't know when it was established. I know that when the Islamic Center went in, it went in with a resolution, and it went in as a continued use. So the use of a house of worship was with the Jewish, with the temple, right?
That was never an issue because
Right.
it was a prior house of worship.
Right. So it was a continued use. Right. Mm-hmm.
But again, just to clarify again, I just took the map that you guys had.
I really directed the question to the zoning official. I said, you're working with the, with the exhibit that you were given. I'm not trying to disparage your motivations or anything. This is only for my clarification as to how I mean, if you look at this thing, and I get it, it looks like a Swiss cheese map. I mean, but, once again, these were long established before zoning even became an issue.
Right. And again, my case that I was just making was that we, a lot of times when you're going for a use variance, one of the questions is, well, can't you go where you belong? And I would look at the map and say, there's no place for us to go. In that case, we're basically destined to go before the board no matter where we go. And I would say that, not that it's our threshold to say, because we're on the secret balancing test, we don't need to say, specifically why this site was chosen, but I would say a TC zone is, I would believe, a good zone for this type of use, considering there's no space for us where we're permitted.
And I'm only bringing this up because in my memory, and I've lived in this town since 1985, it's the only house of worship that's not identified on this map, okay? That, to my way of thinking, it has been a house of worship on that site for at least prior to the current zoning ordinance, let's put it that way. I can definitely testify to that. So it was more or less a point of clarification rather than any sort of, inference that you would intentionally left it out. I didn't mean to. If you took that,
No, I didn't.
No, we didn't take it that way at all.
To the chair or council, maybe I missed it somewhere. There's been several references as to no parking requirement. Why is that? Why have?
Town center has different requirements for parking than the other zones. Page 166.
Do you want me to reference the section? It's 150-12.1B3.
150 parking.
Okay, so specifically for town center, then not aligned with the house of worship thing then.
Right, town center.
So just for the record, looking at the parking requirement for houses of worship, there's one space per 3 seats, or 72 inches of seating space when benches rather than seats are used. So under normal circumstances, in other zones, there would have to be a boatload of parking. Yep.
And again, I think that goes to, the fact that we did perform a parking study as part of the traffic study to show what parking is available in the area. Again, we're assuming people are going to drive here. By no means do I think we're actually going to have zero parking demand. We wanted to make sure that it was not an imposition, but I don't believe we need a variance for that.
Do you think it would be appropriate if that church or synagogue or mosque or something that would be built on the old IHOP location, which is across from the middle school, there's that empty lot there. Do you think that would be appropriate there, given this typical house of worship parking requirement, if that were to be waived?
So you're asking, and for the record, I don't know specifically that site that well. I mean, I've driven the area, I've been there, had, lunch in the downtown the last couple of days, and been to Alpha Fit a couple times. But I believe that this type of use can be appropriate in many locations. I think I think we meet the secret balancing test here. I also think there are many other sites in the TC district that we would be suitable in, as well as obviously I think, having your own parking is always nice to have with any type of institution. But again, I also recognize that one of your goals of your master plan is to kind of maximize the public parking you have. And I think the reason why you have that TC district exemption for parking is that, you want your downtowns to be full of building and not just parking lot, building, parking lot, building, parking lot, building.
As a plan, why would a town center not require parking for each of the businesses or each of the locations in that area?
Yeah, so again, usually successful downtowns have a balance of parking and uses. One, you typically have shared parking. You have uses that are busy at different times of day, which I think you clearly have in that parking lot. I mean, I would imagine if this was approved, morning prayer and alpha, first thing in the morning, as the day kind of goes on, some of the other uses get busy. At night, the lot, may empty out a little bit, and there's some nighttime uses. So I think typically in your downtown, you want to have that shared capability versus if everyone had their own individual parking lot, what you're going to have is a lot of empty asphalt, a lot of, potential stormwater issues where you have impervious coverage, and lots that are empty and the next one's full, the next one's empty and the next one's full. It'll ask for shared parking. And I would also say in terms of downtown, I don't think it's a bad thing to have people walk a reasonable amount because then they do window shopping. Then they're stopping at the ice cream place because they're already walking by that on the way back from something versus you park, you get in your car, and then you just drive home because you're parked right next to your building. So I do think there is benefits to a downtown to having kind of shared parking, and I think that ordinance kind of encourages that.
Mr. Chairman, another quick question here, because I'm just a little bit confused about the issues here. In the original application, they quoted that you needed a relief for 150-12.6C, okay? Parking schedule houses of worship. Are you contending that you shouldn't even be held to that, or if you qualify for the relief? It seemed to be saying in your testimony that you don't even think that that's applicable in this case.
I don't think it's applicable, but if the board wishes, I would put on a variance proof that we believe there's sufficient on-street or public parking in the area that we could satisfy our demand.
As an alternate to the requirement, so you're
Correct.
willing to take it either way, if I'm getting that.
I'll put on the C2 variance if the board believes that we would still need the parking variance.
And I guess I'm looking for clarification maybe from our zoning officer or our attorney as to whether or not this section does or doesn't apply.
Initially, when I reviewed it, I felt it applied.
Has he changed your, I'm going to ask.
It is not within the TC zone, however, this use is also not allowed in the TC zone. So to me, if the use was allowed, it should also have the parking to it. But I would leave that to the final to board attorney.
Mr. Chairman, if I may, rather than, having you further back and forth on that, and I think we've kind of laid the foundation of it, but, Mr. Seckler, can you speak to, in the alternative, if variance relief were required, in your professional opinion, have we satisfied the balancing test with regard to a variance relief for parking, particularly in light of the demonstrated availability of parking that we've shown both in the parking lot as well as the, more than adequate on-street parking?
Yes.
You see where I'm going with that?
Yes, absolutely. And again, in terms of what our standard would be, I think it's also could be up for discussion because the house of worship standard is based on seats or benches, and the prayer area doesn't have either in this case. But again, if I would go to the fact that we would expect to have, and we're saying, let's say 100, we limited to the occupancy. If we do 100 occupants, assuming that's 100 seats, and it's one space for 33 seats, we would need 33 parking spaces. We've demonstrated that during our peak times, which is that Friday afternoon, there are more than 33 parking spaces in public lots around our site. We believe that we do meet that threshold. Again, that public lot is 100 feet from the site, clearly walkable distance from it here. I also, again, kind of going back to board member over here's question, I do believe it's better downtown planning not to have individual parking lots, for each individual use. We're going to do a lot of asphalt, non-walkable environments, need for additional driveways, which is kind of a deterrent in your downtown. And I do believe that the existing parking lots can support this application. So I do believe it's an advancement of planning to allow that variance, if necessary.
Well, I have an inherently bureaucratic background, as you can see, and I just want to know when it comes time to vote, whether I'm going to be voting to approve a variance or whether we're just going to get a ruling that this shouldn't have even been put there to begin with.
And I think we're saying we would prefer to have the variance
be voted on for the sake of.
So you'll be acknowledging the fact that if the variance applies, you're deficient 32 spaces?
33.
33, but the alternative is the spaces in the, your traffic expert testified to 75 spaces in the parking lot and spaces available in the surrounding streets on Bloomfield Avenue, et cetera. Okay.
Correct.
Okay, thank you.
And just something for the board to consider. So there's been a lot of talk about inherently beneficial uses. But I firmly believe that they also have their context and we have to apply that context. So just as of a few years ago in front of this very board, there was a similar case and we have to put it in its context. So, that of course, houses of worship, daycare centers, et cetera, are inherently beneficial, but, the appropriate context has to be applied.
And again, I know that, and I agree with you, and I think that goes into the detriment discussion as it relates to the use that we're in now. I would have a very different testimony if we were, let's say, proposing this in a residential zone. I think that there may be, when you have the baseline of what a residential zone has in terms of activity versus this religious use, that balance may be a little more difficult. And I think the fact this is in the TC zone, and then you look at the activity of the residential use and potential negative impacts of it, I think, again, that, as a baseline, I don't see anything rising really above what we typically see in a TC zone.
Do any other members of the board have a question for our professional planner? Okay. Is there anyone from the public who has a question of our professional planner on the testimony that he has presented this evening? Seeing none. Mr. Jenkins?
Thank you. Mr. Chairman, first of all, thank everybody for the consideration that you've shown this application. The questions that we've gotten, I think, were good and insightful and helpful. And I'm hoping that we have provided you with the sufficient information and tools to make a decision in the affirmative. I'm not going to go through everything Mr. Seckler just did, because in his testimony, I think he summarized very well the balancing that needs to happen with regard to the analysis of this and the review of this application. And we have done that, I think, satisfactorily. The one thing that I want to leave the board with in terms of consideration, which is something that we've said all throughout, and that is to understand what the scope of this is that we're presenting.
Counsel?
Yes?
If you're working on a conclusion, I do have to give the public an opportunity to make a statement on this application.
Oh, I'm sorry. I thought you
prefer
were inviting me to wax poetic. No, I can sit back.
Let me do that first, and then we'll entertain, because you may want to change it.
Okay, I'm sorry. I thought that included any finals. Okay, thank you.
Is there anyone from the public who would like to make a statement on this application at this time? If you would, please come up to the microphone, give us your name, confirm that your town, right? Confirm your town.
Emily Polizzi, Verona. Okay. Can you spell your name? Emily, E-M-I-L-Y, Polizzi, P-O-L-I-Z-Z-I. Thank you. Okay. Variances are sought for undue hardships, typically. Rhetorical question, what is the undue hardship the applicants are facing? I guess I just learned something new a moment ago that perhaps we should not have endured these many hours of testimony. I don't know. This is the third Board of Adjustment meeting I've personally attended on this matter, and I vehemently believe that this burden has not been met to approve the variance being sought by the applicants. In fact, the testimonies presented have illustrated that it is in fact in the township of Verona and the residents of Park Place in particular who are facing a substantial hardship now if the variances are approved. The parking and traffic study in particular served to illuminate the fact that this location is not suitable for the requested intended use. The applicant's statement of facts in their original application did state that as a proposed house of worship, the use is an inherently beneficial use and there is no negative impact. I remain unclear what facts are contained in that statement. Throughout the testimonies presented, at no time were benefits or positive impacts to the Verona community at large, and especially the neighbors residing on Park Place, detailed. After nearly 10 hours of testimony, I've really heard nothing to demonstrate that the approval of the requested variance would be in the best interest of the residents of Verona. This evening, Mr. Jenkins began by referencing this variance as a stopgap, a temporary way of dealing with a problem or satisfying a need. Is approving a variance which will stay with the property indefinitely, bringing with it numbered concerns related to parking, traffic, operating outside the noise ordinances of the township, which will undoubtedly disrupt the neighbors' quiet enjoyment of their property, worth approving? My objection to the use variance is not really about it being a house of worship per se. It's the proposed operations that the applicants are saying will bring to the community in the town center zone. Again, amount of people, vehicles, traffic, hours of operation, parking, and once again, the disruption to the quiet enjoyment of my property. Comment was just made about it being a residential. It also is a residential zone. I am a resident who would be impacted by this variance being approved. I urge the board to consider both the immediate and long-term impact approval of this application would have on the township of Verona. Many of you have sat through the hours upon hours of testimony that have been presented on behalf of the applicants in support of the variance, and it has been informative to be sure, but for me as a resident of Park Place, what I've learned is that there will be a negative impact, a detriment to me, my family, and my neighbors personally if the variance is approved. Hearing that as a house of worship, as an inherently beneficial use, means that the applicants actually don't have to prove the burden of hardship or that the standard is relaxed is quite frankly infuriating. As a resident of Park Place, having sat through the 3 meetings with hours of testimony, and in this final hour being presented with the concept that all of this may have been for naught because a house of worship is a protected class of sorts, it should simply be assumed that the site is suitable, is insulting to me and as a member of the public and perhaps to some of you as the members of the board. I'm exhausted. Perhaps some of you are too. My fear is that if this variance is approved, I will continue to be confronted with issues which are a detriment to the quality of life for me, my family, and my neighbors. Living on a mixed-use street in Verona comes with its unique set of challenges, but all of our neighbors, whether they are residential or commercial, show me almost every day in numbered ways that they are inherently beneficial to the township of Verona. We live here. We work here. We're raising our family here. And we deserve consideration and respect as community members living and working in the town center zone. Approving the variance is a substantial detriment, and I urge the board to take everything that is presented here and make the decision that is truly in the best interest of the township of Verona and its residents. Thank you for your time.
Thank you, Mrs. Belizzi.
Good evening. Manan Razak, M-A-N-N-A-N-R-A-Z-Z-A-K, resident of North Caldwell. I also have attended this meeting for the last 3 sessions, and hearing our expert opinions, the documents, it appears that the documents submitted by the applicant has been reviewed by the police chief, has been reviewed by the engineers, and including the traffic study.
Excuse me, sir, are you a member of
No.
a congregation?
No.
You're not?
No.
Okay.
And we have a clear definition of what beneficial use is. This location specifically allows restaurants, daycares, Chipotle. I've heard over the last 3 sessions how the noise of a house of worship would be detrimental and would cause harm to the community. I think those other uses logically would make more noise than any house of worship. The location itself had, well, the second floor had gunshots. That is a event center that creates even more noise than anyone can imagine from a house of worship. The other question about, I think they had submitted a traffic study with the parking space. 75 parking spaces are there. We just learned what their division of 32, 33. In the June 22nd, 2024 meeting of the Township Council, there's a new parking lot that is being built with 140 spaces on Lakeside that I'm sure that the members of the council is aware of. So that can also help reduce the traffic burden that appears to have to be the big question, if it is. I would think that the council would approve this application, given the expert opinions of the applicants and also the expert opinions of the council, the township itself, the engineers, the fire, and the police department. Thank you.
Thank you.
Is there anyone else from the public who would like to make a statement about this application?
Thank you. Dex Polizzi, Verona, Polizzi. I would be remiss if I didn't point out that all the witnesses presented over these hearings all have financial interests in what they've said. And all of these statements have been made to fit their agenda. I think that's clear. Not once have they expressed that this organization has experienced hardship finding anywhere else to locate their house of worship. And not at any point do I believe that they showed that they would bring value to the Verona community. This is not a public use. This is an exclusive clubhouse for a select few group of people. And the rhetorical acrobatics that we just experienced with this planner were frankly absurd. That said, I am a resident of Park Place, and I have been witness to all of the nonsense that has gone on at 544, 546 Bloomfield Avenue and 10 Park Place. And frankly, it is appalling that this landlord would even consider leasing for this use, given the well-documented history of abuse on this site. I appreciate that Ms. DiBartolo called out the traffic accidents. Let's not forget the shooting that happened on the same property earlier this year. The lack of enforcement to date has been deeply troubling, and my concern is that if this use is granted, that there are no mechanisms for control or regulation. There are a number of issues: zoning compatibility, again, the building being in the town center zone, and referencing the 2022 master plan. This obviously goes against it both in spirit and intent. Simply put, this building is not fit for the mass assembly of people. A restaurant with an ongoing turnover of people is very different than a prayer center that will have congregants there multiple times a day for hours at a time. This unit lacks the infrastructure, accessibility, and location to really support any kind of safety. The hours of operation will infringe on our quiet enjoyment well beyond normal business hours. Friday operations will snarl traffic and restrict access both to residents, people involved in the school, and local businesses. When operations expand to 24 hours, as they do with many other mosques, what can we do to stop these kinds of abuses? It's a rhetorical question. There's really not much. Traffic is obviously a concern. Park Place is already dangerous given its residential and commercial mix. I don't know if anybody was over there this evening with the middle school back to school night. There were at least 10 people parked illegally. Now compound that with a group like this who on a night like this would have prayers at 7 o'clock, and we're looking at gridlock in downtown Verona. Now, obviously, I'm not a planner. I'm not an expert on parking, but I think the space as it stands would require roughly 20 to 30 parking spots if this were a normal situation. Obviously, it's not, but let's not ignore sort of the norms that stand outside of this. We are looking to make exceptions to rules that will have a very negative long-term impact on Verona. Also, I believe that if the use is changed to a place of worship, that would increase their potential occupancy to 300 to 400 people just based on the size, which is scary to think that there would be, even 100 people stuffed in that basement, which used to be a hardware store basement. The lasting impact, again, is ultimately one of my biggest concerns as a resident who lives in downtown Verona. And who has chosen that to raise my family, to start a business, and to be a part of this community. And that's another concern. Nobody there is really talking about the Verona community, only their own. And I cannot say with a good conscience that we should allow this exception and these select few people to have a benefit that goes beyond those of the Verona community. This does not promote inclusion. It does not strengthen our downtown. What it invites is overcrowding, nuisance, enforcement problems, and long-term harm to our neighborhood, and infringement on our health and safety, and ultimately our quiet enjoyment of our property. With that, I respectfully urge the Board of Adjustment to take this issue seriously and to deny this application to protect the integrity of our community and the town center zone. Thank you.
Thank you, Mr. Polizzi. Is there anyone else from the public that would like to make a statement about this application? Seeing none, I would close the public portion and return to you, Mr. Jenkins, for your summary.
Let me start with the positive, that the gentleman who spoke in favor of this application from the public, I adopt the favorable statements that he made as part of, the closing that I would make. I'm rather astounded by the points of opposition that have been made at the public statement. The fact that this is being seen and characterized as a private clubhouse. The fact that this is seen as being anti-inclusionary. The fact that there's a statement that, what is his name? It's like, only for their own. Well, that statement alone patently ignores what we've stated in support of this application, in that the people who are looking to attend this prayer room are of this community. Some live here in Verona, some live here in Essex County. But it's being put here because the need is here, because the desire is here. This is part of this community. Board Member Ryan noted that there was the other mosque that currently exists. Well, that in and of itself says that there is a community in this area that needs to be served and deserves to be served and has the right to be served. The other thing that the comments in opposition ignore are what this applicant has done its best to go out of its way to enforce, by way of the desire and the intent to be a good neighbor. If the board will recall, after the applications and hearings on this, Mr. Suleiman, who is a representative of this application, went around in the audience giving out his phone number, said, "You have a problem, call me. You have concerns, call me." In response to the concerns of, well, is there going to be trash or anything, Mr. Suleiman stated, "We don't know what problems she had before, but that's not us. Because the same concerns that the residents have are going to be the same concerns that they have, because they want to be residents here too. They're not looking to be in an area that is rife with garbage, that is rife with criminality or anything like that. What has been stated is simply, we want a place to pray. We do not want an event space, and we've stipulated that it's not going to be an event space. We want a place to pray. This is not going to be a party room. This is not going to be a wedding factory. There's not going to be any food. There's barely going to be coffee, if any. There's not going to be any noise. At my opening, I stated that we have no problem with the stipulation that you are not going to hear any amplification outside the four walls of this use. So then, to say that this is somehow going to be noisy and disruptive, I'm not seeing it, and that is an actual willful ignoring of the ample testimony that has been provided to this board. Simply put. Oh, and one other thing with regard to, it's like in lumping, there's two things that are happening here, by the way. There is a general lumping in of, you said, as with other mosques. We're not other mosques. They are not other mosques. This is not even a mosque, as we've testified to previously. A mosque has certain things that you would think with it. Event spaces, all the whole panoply of religious services. That's not what this is. It's a place of worship. Yes, it is not a mosque. And to lump this into any other use that with any other problems, again, that is just unnecessarily inflammatory. And also, again, with regard to the current owner, why would they say, well, how dare they rent to this? If the opposition is to be followed here, then nothing goes into this location. There's no stores. You can't have a restaurant. You can't have a nail salon. You can't have all of the other permitted uses that are there, because no matter what's going to happen here is going to be objectionable. So they just want it to be the same arguments, the same opposition that they're asking, or that this board adopt, is the same thing that would happen to any other use that comes in here. Except for the one thing, we've already said, all of those are not us. And we've stipulated to that. So at the end of the day, Mr. Chairman, members of the board, the evidence of this case purely and completely demonstrates that what is coming into this location is harmonious. It is operating at different times than the other peak operations that are going on around it. When the school is letting out, they're not there. When school is coming in, they're not there. When other businesses are at their peak, they're not there. And when they are there, there's plenty of places for them to park. At the end of the day, Mr. Chairman, the evidence that has been exhaustively presented to this board firmly demonstrates that the relief that has been requested is warranted. Thank you very much.
Thank you, Mr. Jenkins. With the applicant concluding, I would open discussions up to board deliberations and would seek to look at the two, just for uniformity's sake, the two variances that are requested. The D variance, permitting a house of worship in the town center zone, and the C, parking availability. I would be interested in hearing what people have to say about both of those based on the testimonies that we've heard.
My concern on this application is the parking lot, the number of parents who... Thank you. Okay, I got it. Maybe the other members of this board can help me on this one, but I'm concerned about the parking lot, the time of day on Friday afternoon when their services are finished. When school gets out at that point, children are all over. They're in the front of the building, they're in the back of the building, they're walking through the parking lot without just running through it and then running up and down Bloomfield Avenue. Getting through Bloomfield Avenue at 2 o'clock in the afternoon on I'm there on many occasions because some of my classes end early, is basically a parking lot. There is a crossing guard there, and I often think that 2 crossing guards might be needed on that particular corner. And I don't worry about at all, I'm not concerned at all, well, I'm not thinking that much about the inside of the building as I am about the health and safety of the young people who are in that area at that time of day. On Friday afternoon, I realize that they say that they will be out of there by 2 p.m. Those are my thoughts.
Thank you.
My thoughts are going on a different direction. I know this is going to be per testimony, a temporary use. So if we switch out the zoning for a temporary use, what does that do after the tenant moves out?
I'm sorry.
After temporary use. I mean, this is short-term lease. So if we change out the zoning for, well, we're looking to put a house of worship into a business zone. So if we're approving
We're approving the variance, right?
the variance of this use
It would run with the land,
with the land.
yes.
So then moving forward, it would always be that use.
Correct.
Unless someone comes back at a
With the
later time.
restrictions, if the board were inclined to approve it, with the restrictions that were imposed as conditions. So if the board said, well, we're going to accept this testimony and agree on a condition that it would be no more than 100 people, that would apply to any subsequent tenant as well. So they would apply, but, without anything that is not restricted by condition, then would be available, pursuant to the permission granted with the variance.
What are the limits on conditions that the board can impose? Can we impose a time limit? Like no longer than a year or no longer than 18 months?
No, because that would then try to circumvent the fact that it would run with the land. As far as other conditions, that would be after the board decided whether this is an inherently beneficial use or not. Because if it is an inherently beneficial use, as you heard the planner's testimony, then conditions are, if the board were inclined to approve the application, then the board could offer conditions, the applicant could accept conditions, et cetera, as the applicant has already offered conditions. If it's not an inherently beneficial use, then the opportunity for conditions still arises, but they're not as critical of an element into the determination.
My understanding of the case law is that to the extent we were to find it's an inherently beneficial use, we also have an obligation to sort of weigh any potential conditions that.
Correct, that's exactly, that's what I was just trying to express.
Okay, thanks.
So I have a bunch of random thoughts that I scribbled down. A 4 a.m. potential ingress, so people coming to the site at 4 a.m. in what's otherwise a pretty quiet neighborhood. Granted, I've actually never been in Verona at 4 a.m., but I'm assuming it's somewhat quiet. That's a consideration. Number two, there's not much of a time buffer between that Friday afternoon 2:30 exit versus when the kids get out at 3 o'clock. It's a little bit on the tight side. In terms of the noise, I was actually sitting outside at Town Scoop one Wednesday evening in June at around 8 p.m. and the avenue was very loud. You could hear the music from there. This could be a Starbucks. And just imagine if it was Starbucks, right? I feel like the application itself was a little bit messy. I think the design professional drawings could have been a little bit more enhanced to create a stronger case. I'm concerned that the occupant load on the architectural drawings is cited as 156. That's a lot of people. There's other uses in the area that are also, utilizing that same parking. We didn't even kind of talk about that or all those extra uses. I tend to shy away from a permanent solution to a temporary problem. And just lastly, the idea that if this was a Starbucks, there's probably, or some other kind of use, and there's some, kind of off and on, people who come to the site. To have all these people come at just this one time of day, particularly on Friday afternoon, that's a little troublesome to me. That being said, this is not a football stadium. You're not dealing with 30,000 cars. So there's a lot to consider.
Yeah, I guess I'll go through my list of thoughts as well. I think you touched on it as well, and I'll piggyback on that one. The uncertainty on the future utilization or improvement plans on the facility for me, and I appreciate kind of the planner's testimony on it, for me it raises a health and safety concern. The venue, hasn't kind of had a great historical track, and if parking is questionable in the TC zone, then what else might potentially be skirted on by the owner? Again, we haven't had that investment here from the owner, so not knowing what the future of the site is going to be, especially with what was presented as potential needs for a house of worship, that for me kind of still presented a bit of concern in terms of what the venue would actually look like or what changes would be presented there. The traffic impact study for me was still kind of lacking. That's kind of Verona's equivalent of a 5 points neighborhood. And early morning, late evenings, utilization concerns. If there are points where we have kind of extended utilization of that particular downtown area, then even with 20, 30, 40 people having to maneuver in and around that area early or late evening does present a health and safety concern for me, especially crossing Bloomfield. Consistently, there's just this back and forth dialogue. And for me, I just keep seeing it as kind of a negative criteria, and that is that temporary in nature while we're talking about kind of tied to the property element. And this is just seems like it's a very, I don't know how else to phrase it, like self-licking ice cream cone, temporary solution for a permanent problem thing where it's convenience for the group. This is not open, it's not, and I understand what was stated, but at the same time, it's consistently stated temporary solution. I don't see where there is going to be an intent to grow. There are not other activities going on, not other investments going on to do other things. And quite frankly, I understand what you're saying or what was said, but if there were other activities, non-house of worship things, I just don't see what else besides. There was no talk about growth for the group. There was nothing else to demonstrate. I don't know, just I know we're not supposed to look at positive criteria or whatever, but there was just no growth at all. Another concern for me is just given kind of the apportioned periods throughout the course of the day, it's all meter targeted in that area. And what that's going to do, in that vicinity as people kind of look at, creative parking solutions, and or, as that becomes a potential issue over time, that to me also presents a concern for both this community and those around them. So for me, the noise, I don't think the noise for me was I'm not going to speak for the community there, but there's just a series of just unanswered questions and things that I just couldn't get past in the way that I kind of looked at this, and yeah, that's where I'm at.
Mr. Chairman, I guess my thought process really totally is reliant upon the safety issue there. That area is already a safety hazard, okay? And I, morally and in good conscience, do not want them to do anything that is going to exacerbate the horrible traffic and safety conditions that exist in that area, specifically that intersection. It was horribly designed. If I wish I could go and change it somehow, believe me, I've looked at a number of possible mitigation factors, and nobody, unfortunately, has come up with them. I think to Mr. Tully's point, the traffic study is wonderful as a little snapshot in time. I've lived, and I think why we have these boards here with residents who've had actual experience with traffic conditions. I think I mentioned at a prior meeting, I've lived in this town since 1985. I bank there. I go to I had a child who went to school there. It is a horrible situation as it currently exists. And just putting, I think Dr. Reese mentioned, just large concentrations of additional traffic at specific times of the day is not going to help the community or this congregation. I think the planner mentioned one of the only reasons why we could possibly say it wasn't an inherently beneficial use was due to health and safety conditions. And that's what I'm going to be seriously, rolling over in my head is that the only place where this congregation can find a location? I don't think it is. that doesn't have to exacerbate the already horrible conditions that exist there. In my mind, it has nothing to do with the religious beliefs of these folks. And I do take exception to some of the comments that people have made, regarding, I'm sorry, they're not a club, to one of the people in the audience who's, to me, made sort of a disparaging remark. I find that kind of abhorrent, because I think it takes away from the other legitimate points that he made about just the general conditions in that particular location. So, in my mind, you haven't convinced me at this point that this is the only alternative you have, and that our concerns about safety and additional traffic in that extremely horrible location and the inconvenience that already exists for the residents who live on that block is not going to be exacerbated by approving this application. And to the point that you made, Mr. Jenkins, well, if another restaurant or somebody wants to come in and go before the planning board, that'll be their decision. They can go in and look at, if they don't need a D variance, they can go before the planning board, and they might even not have to go before a board. So you're very correctly stated that, but that's not up to this board to decide. We are charged with, granting a D use variance, and in my mind, it just doesn't raise to that. Because of the safety issues, it doesn't meet the standard for us to grant that type of variance.
And just to be perfectly clear, I think if this congregation, of course, would be welcome in this town, very, very, very welcome. Just this is a very tough spot.
But I think when we talk about the safety of this one block, I don't think it matters who goes in here. It's still unsafe. So I don't know if we can necessarily take one application just because of what we feel a safety concern is going to be, where it's more of a global issue on like what happens in this community and how we are able to control how our children leave the school, how we drive, and how we park our cars on this particular block. People are reckless on the street. People are trying to get to that parking lot, beat people to that spot. That isn't how we should put these restrictions up on these blocks for a particular reason. You have, the signs on how you should come in and park and where you should park and how you do it. It's, the care that people have to take once they're in these areas and how we, exit the school. So we do have, as a community, have to be able to learn about what we have to do about making this area better. And it doesn't matter who comes into the spot. This concern's there. This concern's been here since you've lived here, Kevin. I understand that. And you haven't been able to do something to improve that. I know we've had multiple meetings and multiple groups on how we can do that. Okay. So I just think we need to, we do as a community have to figure out how we can solve the safety issue of this block and how we pick up the students and how we do those type of things. So I think we got to take it on like the merits of what, the use of this building is going to be and what the use of this town is going to be for this particular block.
If Park Place exited someplace else, I don't think that I would have so much of a concern. But it's basically like a dead end.
Yeah.
No.
With no turnaround. Or
I think I'd like to take the safety issue to the building itself. This is the basement of Wright Hardware that is going to hold 150 some people in a windowless environment with entrances and exits that we were kind of told would be modified, but not exactly how. They just be compliant with whatever they needed to do. That particular structure that area within the building. It's not like we're looking to approve a building on a property, which is what a lot of the descriptions of worship and everything else indicate a building. We're looking to approve an area in part of the building. And I don't believe the area is safe as a gathering place. I have questions about having so many different uses in a building in town center where permitted uses are quite the variety. So that's kind of, from the safety perspective, that's what rubs me, I'm uncomfortable with that. And like I believe everybody else, at least has voiced, I'm uncomfortable with a variance for an area that's going to remain in perpetuity, even though the applicant has stated that they are looking at this as a temporary location. That becomes one more area the town has to monitor, people going in and people coming out and what's agreeable. We already realized tonight that we have one area that doesn't show up on the semi-public zone, which is in a residential area, that by virtue of the permission to use that space, and it continues to be used as that, we would require an awful lot of conditions in order to make this space fit the town center for the foreseeable future. I think, can I sense that if we were looking, the public interest here, do we need to determine if this is inherently beneficial? Yes. I think we're okay with some of that language. And I think in responding to that, we're coming up with several different areas of health and safety that represent a concern, a considerable concern for this particular property. And that's what we look at, this particular property, which has several pieces to it, several moving pieces. So. Counselor, do we need to identify anything in particular if we are going to?
Well, Mr. Chairman, I would recommend to the board that it first determine whether, in fact, the board is considering this as an inherently beneficial use. And if it is considering it as an inherently beneficial use, then it would be the balancing test of the positive and negative criteria. So just, for the record, if the chair would poll the board or take a vote from the board on what standard it's actually applying to this application.
I would just like to, I do want to state that I do believe that there are many laudable aspects to this application. I do. I do think I do think a house of worship is an inherently beneficial use. I just do. And I recognize the fact that this particular use would serve members of our community and members of the community that live around us. And those are all good things. And then in addition, it would bring more people and more foot traffic to our town center. I don't think you can ignore that. But I also share the safety concerns that others have raised. But if we're going to be voting on whether this is an inherently beneficial use, I believe it is.
If I may, Mr. Chairman, just one comment, and first of all, thank you for that recognition, but I just want to object that there is even any dispute that this is an inherently beneficial use. I think that that is not a criteria that the board should even be entertaining. And if you do not believe it, again, we just can't say yes or no. I don't see any rationale for saying that this is not an inherently beneficial use. As the board is doing its deliberation, I just want to put that objection on the record.
Okay, thank you.
Can he ask a question?
Well, I think what you should,
Mr. Chairman, can you sort of clarify that last statement for me? I mean,
I think the board should just continue. The objection is noted. The board should continue on the course it is going.
I didn't pick up all of his objections. I just maybe you could repeat that.
Well, I'll summarize.
Yeah, you summarize.
Mr. Jenkins says that we should not necessarily be considering whether or not it's a inherently beneficial use. That should be a given. We should go on that as the assumption. And it's not listed per se in any of our municipal land use laws. So I am of the belief that we probably should consider it rather than just go ahead and say it's a fait accompli.
Forgive me, one point of clarification. When you say it's not listed in any of our municipal land use laws.
I believe the testimony was that it comes under the others.
So what was the testimony is that there are certain particularly enumerated uses that have been specifically recognized, like a hospital, whatever. There's also the catch-all, amongst others. We all know that the states, the laws of the United States, and particularly of New Jersey, is, yes, there are statutory requirements that are amplified or restricted by the actions of the court. And we have stated on the record that the courts of this state have recognized that inherently beneficial uses include houses of worship.
Mr. Jenkins, if I could, okay, that has nothing to do with the board's deliberation. If the board is willing, the board wants to put on the record what the standard it is voting on, okay? There are two different standards, we agree, of whether there's an inherently beneficial use or whether there's not inherently beneficial use. If it's not an inherently beneficial use, then there's the positive, negative criteria, the enhanced quality of proof, et cetera. If there is an inherently beneficial use, then you don't have to prove your positive criteria, and it's a balancing test. So the board needs to establish what standard it is applying and then apply that standard. You are suggesting that we just say that it's inherently beneficial. That's what the board, by what I hear, will get to. And then based on that, their decision will be based on the criteria, the SECA criteria, that say there was a balancing test, and there's 4 criteria set forth in SECA. So the board is just creating its record to make its decision.
My statement was a limited one with regard to what I believed I heard the chairman say, that there was no stated inherently beneficial.
That's correct.
Use. But I was clarifying that,
in your opinion, right, in my opinion,
just like an objection is in my
right.
by
In my opinion,
but
house of worship was based on a stipulation. The court never decided that it's inherently beneficial use. Just to look at that case in particular, but this isn't relevant to where we are right now.
Again, right. That's fine. Okay. I just wanted to make sure that the board was not under the impression that there was no playing field on this whatsoever. That there has been some guidance, whatever, and there are guardrails on that, and as modified by your statement there, but it is not the Wild West of a determination. That was my specific pointed objection with regard to that.
Well, the board has every right to make that determination.
I understand that, but I still got to say it, and I still disagree.
Noted.
And I guess just for me, I'm still kind of wrapped up around the degree of the house of worship that we're measuring here. I mean, this is a portion of the practice, not the totality of the practice. So while I apologize that I didn't read all the case law for the previous ones that were mentioned, in past, but again, this is a portion of the practice, which is where my concern with the limited availability of what this house of worship, or as mentioned, brings to the community. As stated, not a mosque. It's a portion of the practice. Equally would be part of any other religion. There are portions of the practice. So that's what's being discussed here, a temporary location to execute a portion of the practice until another venue is found. So again, I didn't read all the case laws. Potentially the other venues may have been a full service, brought other things to the community, as do other religious institutions and communities that I'm aware of, including mosques. This is where I don't know if degree of house of worship comes into question about, inherent benefit or whatever, but that's a question that I have about that.
My guess is probably not, because if it's a house of worship, it doesn't matter what the.
But so if it provides medical services, it's automatically a hospital?
Well, no, but I'm just saying the classification of a house
All
of
healthcare
worship
is all healthcare.
kind of is
all childcare
and that's
is
why
all
it's usually
childcare.
defined, and in the ordinance it's defined as X, Y, Z, and then the case law kicks in if there's any interpretation open to that.
Yeah, I mean, I think that there are degrees of other classifications that we have where at a certain point you are this and you're not.
But since we're granting this use variance as a house of worship, it's subject to that range, right?
If.
I would just say, in my opinion, I think this board would make a grave mistake if it made a determination that this was not an inherently beneficial use.
I'm not so sure
And
that
then
that's in
apply
question,
the
though,
proper
is it?
balancing test.
I'm not so sure that that's in question. It seems like we're.
I mean,
Here's the way we approach it.
right. It needs to go on the record that that's the standard that you are applying, if indeed that is the standard.
And then we can move on to the
Exactly.
Yes.
So, shall we conduct a vote to see? Okay.
What are we voting on specifically right now?
Specifically, we're voting on whether or not we're going to address this matter as an inherently beneficial use. The application of this house of worship as an inherently beneficial use. It's the difference between what we come up with in the way of positive and negative criteria. If we said no, then we would have to.
When we use the term here, inherently beneficial use, are we thinking of the entire community, or are we thinking of an inherently beneficial use for a particular group of people who would enjoy it and use this facility? Is that what we're going?
Well, that's a very good question, and generally speaking, the specific uses that are set forth in the statute are generally for everybody. Many of the uses, like hospitals. Hospitals are for everybody. It's not just for, one group of people or the other. The religious uses, however, are generally for people of that religion, but they are still, in some cases, considered as inherently beneficial. So it's not the entire community, because religion has been determined to be helping to promote the general welfare. So
And that spills over into the community.
Exactly.
As well.
Right,
The diversity spills over.
Exactly.
into the community.
Right.
So one could make an argument that even though it's a limited group of people that is using this facility, that it is inherently
That is
beneficial.
correct. Yes.
As are all of the other religious Or
You can make that-
houses of worship.
You can make that argument, and it's easy to justify.
And the MLUL specifically cites daycares. So not everybody has a child in daycare, but that is considered an inherently beneficial use.
I think too, is doesn't the congregate care homes, right? The places where, I mean, you don't have to be in need of a congregate care home or have to, you just don't.
I'm going to beat it a dead horse here, but I'm trying to go back to the planner's testimony. Okay. He threw out a lot of information there. Okay. If my understanding is correct, the initial decision did not include houses of worship, Counselor, but then as court cases went on, that they sort of got included with the hospitals, the daycare centers.
No, I think it's because statutorily it was not included.
Okay.
But I'm not familiar with any cases that said, well, I think there's one outlier, if I can recall, that ruled that a house of worship or a religious institution was not inherently beneficial. But consistently, it has evolved that way. And then I can never remember the acronym RUPLA, right, with RUPLA, it has become codified federally. So it's definitely trending heavily in the direction that it's inherently beneficial.
So are we okay with identifying this as inherently beneficial? Is there any reason we need to vote on it? Does anyone want to be recorded specifically? Okay. It looked like it was unanimous to me. Okay. Given that, most of the comments we've heard have been along those lines that the planner raised as far as having to do with safety. And the question is, do enough of them, are they strong enough, and are there enough of them? What are your thoughts?
Yeah, I think it's important to realize that just because it's an inherently beneficial use, you can't just plop that on any site and make it acceptable, right? Again, you need the context. Yes, the experts and the professionals did testify to the fact that there would be no issues. I think in reality, all of us who have lived here and experienced this intersection have had different experiences.
I mean, I think there are significant safety issues, and that those are the detriments that I'm thinking of when I'm thinking about what are the detriments if we were to approve this application, right? And then I know we have to consider, are there any conditions that we could put on it that would alleviate those issues? And I'm just hard pressed to come up with any conditions that would alleviate that particular detriment.
One thing that I actually just thought of is that this intersection happens to be at the bottom of our valley, right? So in both directions, there's people flying down the street not adhering to the speed limit. And it's hard to stop. And they're kind of like at the heart of it all.
Could we ask them, would a compromise be to ask them to change their hours of worship? Like that's, you can't do that.
We have to make a decision based on the testimony.
Mr. Chairman, if I can, I just want to remind the board of one of the conditions which we've already agreed to, which was already thrown out there, is the cooperation with the police department. That if everybody else seemed to agree when we were discussing it before, that a police presence, as necessary, would be beneficial to this area. This applicant has already agreed to do that and work with the township on that, the borough, excuse me. So again, I'm just reminding the board that there is an actual very stern and workable condition with regard to the traffic flow itself.
Mr. Jenkins, for the record, you had said they would work with the police, but there was no proposal for police on site directing traffic at all times during worship hours or anything like that.
I mean, that was, I guess, kind of the thrust of that. If my client has already agreed that if there were additional police required and to be paid for, they would do so.
The record will show it.
Yeah, but either way, if it doesn't reflect it before, it's confusing before, it's clear now.
All right. Are there any more thoughts on this particular aspect of the application?
I just don't think these restrictions would necessarily be enforceable. You can write all you want, regarding, or we'll work with the police, and, suppose the department is shorthanded on a particular day, and the chief, right, goes back and says, well, I don't have any extra people to put out there, but we want to have a special, police presence at Friday afternoon, let's say, when we have a lot of people that are going to be coming to the prayer room, and he just says, well, I can't spare anybody today. I have 5 guys who called in sick. So you can write all these stipulations, as you well know, Dan, into these approvals, but we don't have any enforcement. We have to be realistic when we put a restriction in as to whether or not it's practical or enforceable. That's just something I'm throwing out there.
Key.
I think part of my issue with this is that, we're talking about potential fatalities. I mean, it's not like this, a disruption of something just sort of aesthetic or slightly inconvenient. I mean, this is potentially like children walking across these streets, and they're already so clogged. And I think just the magnitude of that is troubling.
Am I sensing a direction? Okay, sensing a direction and hearing one are two different things. So for that purpose, I'm going to need a motion with regard to this application.
I will make a motion with incredible sympathy to deny this application.
Motion to deny. And is there a second for that motion?
Second.
Okay. We have a motion and a second. May we have a roll call vote, Kathleen?
Dr. Reese,
I vote to deny.
Dr. Cortez,
Yes.
Mr. Ryan,
Yes.
Mrs. Murphy Braddock,
Yes.
Mr. Mathewson,
Yes.
Mrs. DiBartolo,
Yes.
Chair McGinley.
I vote yes. And by my count, that motion was approved to deny the application. Mr. Jenkins, thank you.
Have a good evening.
Does anybody need a break?
Yes, I agree.
Hmm?
You got another application?
Yeah. Okay, we're going to go for a break until 10:25.
I'm recused.
In addition to other and it can only park in. So there's cars coming and going, and think about
We're going to go back on record, and after consultation with all of my colleagues, and given the fact that it is now 10:30 p.m., Counselor, we would like to carry application 2025-04, 271 Grove Avenue, to
October 9th.
October 9th.
October 9th would be the next regular meeting.
Would you be so kind as to?
That's fine, Mr. Chair. As much as my client is anxious as she is to have this heard, we understand the lateness of the hour, and this is not going to be a 20-minute or a half-hour application, so
We'd like to be fresh when
as
we do it.
volunteers, and, we'll be back, we'll come back in 3 weeks and present our case. We'll hopefully be the first on the agenda for that meeting.
Yes.
Kathleen? Thank you.
Unless a little fence comes up.
What's that?
Mr. Chebulakin, you just obviously
Consent,
expressed
yeah,
consent
consent.
without using the express words, so. Okay.
We consent to any necessary extension
Actually,
time, but
Thank you.
I'm sorry, but we were waiting 6 months to be heard, and if we can't do it tonight, then that's understandable, we'll figure it out, but we have 3 little kids, we're a Verona family, we've been here all night listening to something just ridiculous, which is fair, that we have to, we would have liked to have been able to in person, if we can't, then that's fine, but, 3 hours of a babysitter to try and be here, we've gotten pushed off 3 times. We're getting pushed off again. It's very difficult. Sure you can empathize. So we consented, we're okay.
Counselor, some of the board members have extended a certain amount of sympathy to the applicant, and we typically don't hear any testimony after 11. Is it likely that you would finish your application between now and 11?
I understand everybody is late for everyone, and so that I just.
Okay.
I'd love to say yes, but I think it's highly unlikely. That we would finish by 11. We have 2 witnesses.
Okay, yeah, that would be extremely difficult.
And finish her testimony before 11, and certainly I'm going to finish 2 witnesses before 11.
Then it stands carried to October. Okay. Folks, any reason to go into executive session? If everybody's had an opportunity to look over our upcoming schedule, on October 2nd, we have a special meeting for this same property.
Just go ahead and sue the town to say they had approved the application and leave us out of it.
That'd be our first question.
I think they had a very good case.
October 9th, we have the continuation of 271 Grove and the application of 3 Claridge Drive, also another use variance. November.
I can't sit on that, can I?
Nope. Oh, no. You're within 200 feet.
last time we didn't notice. If I noticed,
I would personally get.
personally noticed.
We got, in November, we have our first case with 5 variances requested. Oh, no, just November. And another use variance. Another use variance for someone who wants to create a garage.
I just want to talk about, like, if you go and have a decision made about at least what we can control in terms of like extraneous comments, I think we should really.
It's not executive session, we're still in meeting, you can.
We can cover that here.
Yeah, I mean,
I just want to echo, I think the chairman's comments at the beginning of tonight's meeting, which was just given the volume of applications that we have, given the fact that we want to make sure that we allow applicants the appropriate opportunity to be heard and present all of their testimony, I would just urge everybody, and I'm not suggesting we don't ask questions because that's our job, but be thoughtful about sort of the length of time that we are spending and making sure that we're asking thoughtful questions and important questions, just because otherwise, and kind of keep extraneous commentary to a minimum until it's time to sort of, deliberate. It would be just my request of the board, because I think we'll be able to get through a lot of things a lot faster.
And
We had
focus.
a conversation down here, though, and I corrected this with Kathleen. I didn't want to get into a shouting match with that lady, but they knocked themselves off twice. We didn't refuse to hear their application before. They
Right.
requested
Moved it.
postponements. Am I correct?
Well, they were only
She-
on one,
Yeah.
and they requested to be adjourned, and then the next time.
What does that have to do?
Yeah, but this is exactly what I'm talking about. That, what you just mentioned has nothing to do with what I just said. In fact, that's an example of an extraneous situation that we don't need to talk about because they're not here anymore. And they're going to come back the next time. So I just think that if we could really focus on that, because we have a lot of applications and we're doing a lot of meetings, a lot more meetings than we normally do to try to get through them. So I just think.
So that kind of reaction doesn't happen.
Exactly. And for us, because,
Right. That's it. Yeah. So we'll continue to be efficient and focus on the variances and allow the applicant to plead their case, and they have to make the convincing argument. We don't have to pull it out of them or make it for them, unless it's the guy with the fence. There's always going to be a guy with a fence.
Right. Do you think it's substantially detriment to the public good? No.
Where are you putting that fence? Is there anything else? We obviously don't need to go into executive session. We can
No,
discuss anything.
but to Genevieve's point, if anyone, when you get your packets, if there's any questions regarding the denial or the zoning, you can absolutely reach out and ask me directly before we get to a meeting as well.
Can we do that?
I thought we had to do all things in public.
No,
Not clarification.
Okay.
and just not with a quorum. I mean, you could talk to another board member, not about the business, but as Dan said, for clarification,
Perfect.
thing, sure.
Oh, that's great.
Right.
Thank you.
Kevin and I talk for hours. Right?
We haven't talked in months.
I know. I've been on vacation.
So was I.
I missed you.
You didn't
No.
go vacation together?
Question, for some of these, can we not get a heads up from the applicant about how long they intend to, like,
discuss?
This guy obviously has an idea of time. Like, when I saw the application, I didn't think it was going to be longer than 30 minutes, but apparently he has like an hour and a half. Like, is that not something, like how many witnesses or whatever?
We can certainly ask. Most of the better attorneys have a pretty good idea of how long their people are going to make a presentation.
Okay, I was just curious. I mean, apparently October 9th, we're starting off with like a hour and a half meeting already. So.
Yeah.
Okay.
Yeah. Yeah, that's That's where we,
Forecast.
No, look, I think your comment's a good one. It goes to how can we most expeditiously do these hearings in a way that gives the applicant an opportunity to be heard fully and gives us the opportunity to ask appropriate questions, but without, unnecessarily dragging.
There was zero public.
yeah. Yeah. After you do this for a few years, when the applicant says, I have 4 witnesses or whatever, you can kind of pretty much,
I especially know that in advance.
Especially with this board.
yeah. Yeah. Okay, hearing no reason to go into executive session, I would enter.
To adjourn.
Thank you very much. Consider us adjourned till October 2nd.
And then you'll have 2 in a row, the 2nd and the 9th.
Second and